Robert Hur, the special counsel that was looking into Vice President, but now President Biden's possession of classified documents. Let me get a couple of points out of the way right in the beginning. You're going to hear from myself, Harry Hutchison, and Andy. Jordan's going to be joining us from Strasbourg a little bit later. Our position is this. Neither one of these cases should have been brought. The case against President Trump certainly should not have been brought because he was president of the United States and had the authority to declassify. Joe Biden was vice president of the United States, did not have the authority to declassify, but we don't think either one, but he's the sitting president of the United States, so you cannot be indicted while you're president of the United States. But I think the biggest issue that has come up on all of this, and we'll get into what the memory issue means and how it plays out, but I think it's important to play for you a question from Darrell Issa to Robert Hur about the status of guilt or innocence of Joe Biden.
I'm going to presume that you would never prosecute someone you thought was outright innocent.
Correct.
In this case, did you reach a conclusion that this man was outright innocent?
That conclusion is not reflected in my report, sir.
Right. So you did not reach that conclusion, or it would have been in your report.
I viewed my task of explaining my decision to the Attorney General as being based on my judgment and my assessment of the evidence. Would a conviction at trial be the probable outcome? And that's
and I just want to make sure the record is complete in that, because I think it's extremely important. You did not reach an idea that he had committed no wrong. You reached a conclusion that you would not prevail at trial and therefore did not take it forward. Is that correct?
Correct, Congressman.
Okay, so I'm going to go to Andy first. So what is he saying there?
What he's saying is this. I looked at the evidence in the case. I interviewed Biden. I made a decision that his memory was of such bad quality that it is unlikely I could have gotten a conviction at trial, because a jury would not believe that he, this man Biden, had the intent to commit an act intentionally, willfully, and knowingly. And therefore, because I didn't think I could get a conviction at trial, I declined prosecuting him. That's what he said.
Harry, and I think that's, by the way, we're going to give you the legal analysis here and really break this down for you. I don't think either one of these cases should go forward. Sitting presidents cannot be prosecuted. We've argued that for President Trump. Same would apply to President Biden. How do you read the takeaway right there on the innocence issue?
Well, I would first state, consistent with Mr. Issa, that Biden did indeed mishandle the documents. He knowingly and intentionally did so, and that Biden was possibly guilty of a criminal charge, and clearly he was not innocent. But instead of bringing the charge, or at least positing that he might be chargeable, the special counsel, Mr. Hur, suggested that Biden put his own memory at issue, and therefore a conviction would be difficult under the circumstances, even though he may have had the intent at the time the misconduct occurred.
Let me play for you the bite of Representative Kelly Armstrong to her about where the documents in the Biden investigation were found. It's pretty startling when you hear it.
Mr. Hur, classified documents were found at the Penn Biden Center?
That's correct.
They were found in President Biden's garage?
In Wilmington, Delaware, yes.
And in his basement den?
Also in the same home, yes.
In his main floor office?
Correct.
And his third floor den?
Correct.
At the University of Delaware?
Correct.
And at the Biden Institute?
Correct.
So let's go ahead and take Dave's call from California on line one. Dave, go ahead. You're on the air.
Hey, huge supporter of ACLJ.
Great, thank you.
I believe in the American public. I am very disappointed to hear you guys support her and the special counsel's recommendation not to file charges or not to go forward.
Why are you disappointed? Our position for President Trump is that a sitting president cannot be charged and prosecuted. That was our position that I advocated before the special counsel against him, Bob Mueller, and ultimately prevailed on that you cannot indict a sitting president according to the Department of Justice guidelines. So, Dave, do you disagree with our position on that?
No, I agree with your position on that. But once they took that forward, and we've spent millions of dollars to do this, and to sit here and think that because Biden and his attorneys probably played a little game and said, "Oh boy, we don't have we can't remember that. We can't, let it go to trial.
But you can't try a sitting president. You cannot bring an indictment against a sitting president. That's Department of Justice guidelines, and it's based on the separation of powers in the Constitution. So I appreciate what you're saying, Dave, and I understand the frustration. But we have to be consistent, Jordan, with the constitutional position.
We do. I mean, I've heard that throughout the hearing today, too, and I know it is frustrating for people when you hear, how many different places he had classified information. And, Dad, when I think that line, when her said that recording that he had of Joe Biden telling his biographer that he made, that wrote the book for him, the ghostwriter, $8 million he made. He said, "Hey, I found the classified documents. I've got them for us." I mean, that's $8 million worth of crime right there that can't be prosecuted.
But you don't indict.
And I know that it is frustrating.
Yeah, I understand Dave's frustration, but you don't indict a sitting president of the United States. I'm going to play Congressman McClintock's statements. I think this is really helpful here, folks. Take a listen to this.
So the answer to my earlier question is correct. All I have to do when I'm caught taking home classified materials to say, I'm sorry, Mr. Herbert, but I'm getting old. My memory's not so great.
Yeah, Congressman,
This is the doctrine that you've established in our laws now, and it's frightening.
Congressman, my intent is certainly not to establish any sort of doctrine. I had a particular task. I have a particular set of evidence to consider and make a judgment with respect to one particular set of evidence, and that is what I did.
Here's the problem with what Robert Hur said. If someone's, and I use the example of a vehicular homicide. 5 years ago, they committed vehicular homicide. They're being prosecuted. At the time that they committed the act, they had criminal intent. They were negligent, or whatever the standard is in the state for vehicular homicide. The fact that 5 years later, Andy, they don't have a really good memory doesn't negate the intent that they had at the time the trial was committed if there's evidence to show specific intent.
That's exactly right.
So Hur is wrong on that point.
He's right. He's incorrect. If you have the specific intent at the time of the commission of the offense, I would say prosecute the case. But what he is saying is now, with the passage of time, and after they've interviewed him and after he's made his statement, that's a luxury you don't get if you're a prosecutor to interview a defendant in making that decision. But he says, I just can't see a jury convicting this guy.
Harry brought up another point, Harry, really quickly here, and that was the fact is, Delaware or Washington, D.C., the jury's going to be very pro-Joe Biden.
Absolutely. And so it's the sympathy of the jurors, or put a different way, the prejudice of the jurors that works in Biden's favor.
Let's take Scotty's call in Missouri on line 2. Scotty, go ahead.
Yeah, so if President Biden's mental capacity is so bad, should he be reelected as Commander-in-Chief of the United States?
That's the $64 million question. His memory's so bad, he's a nice old man, but he's got this really bad memory. Do you want him running your country? And Robert Hur is dancing around that issue, but it's not so easy. I mean, and Andy mentioned the legal standard, but Harry, from a policy standpoint, it's a really good question.
It's absolutely a great question, and the question is amplified because many people have similar doubts about the vice president's capacity to operate as president. So I think this is a judgment ultimately that has to be made by the American people. And they have to decide between 2, perhaps even 3 candidates for president this fall, which of those candidates is most qualified. But at the end of the day, the caller's question also underscores the work of the ACLJ in trying to assure the American people, or ensure that the American people have the right to vote for the candidate of their choice. And we have been active in making sure that Donald Trump was not unjustly disqualified from the ballot. So I think ultimately the decision will be up to the American people.
And no doubt about that. And that's another reason why you should be supporting the work of the ACLJ. We've got 18 cases against the Biden deep state right now, 18. But we also, as Harry just mentioned, were counsel of record for the Colorado GOP after the attempt by the left to remove Trump from the ballot. We were successful in that case 9-0. We're working on a brief on the immunity issue right now. That is also at the Supreme Court. We filed a brief on the issue of what is the First Amendment implications of an overly broad interpretation of interference with Congress. Judge Katsas at the U.S. Court of Appeals for the Court of Appeals for the District of Columbia agreed with our position, and that is now at the Supreme Court of the United States, too.